Chapter 3. Issue of shares. Question 5. Answer in brief. 4 marks each. 1. What is book building method? Answer. Book building is a process of price discovery. It is a method under which the issuer company determines the number of shares and the issue price at which its shares will be sold by bidding process. The company issues a red herring prospectus wherein price range or price band is mentioned and the investors are asked to bid on it. The lower end of the price band is called as floor price and the upper end is called as cap price or ceiling price. The final price at which shares are offered to the investors is called as cut-off price. Bidding is kept open for 5 days, during which period bids are collected from investors at various prices which are above or equal to the floor price. The bids, along with the application money, are to be submitted to the lead merchant bankers, called as book runners, who enters the bids in a book. After the bidding process is complete, the cut-off price is arrived at, based on the highest or best price at which all shares on offer can be sold. The final prospectus, with all details, including the final issue price and the issue size, is filed with the Registrar of Companies and issued to the public. This method is used for public issues, that is IPO and FPO. 2. State the provisions for rights issue. Answer. Whenever a company proposes to increase its subscribed capital by issuing further shares, it can offer those shares to the existing equity shareholders in their existing proportion. Such an issue is called as rights issue of shares. Following provisions are to be fulfilled by the company making right issue. A. Rights shares are sold to the existing shareholders at a price which is lesser than its market price. B. A letter of offer has to be sent by the company offering right shares to the existing shareholders. C. The letter of offer shall contain the following information. 1. The number of shares offered. 2. The period of offer, that is, the period of offer shall not be less than 15 days and more than 30 days from the date of offer. 3. The right to renounce, that is, the shareholders have a right to give up their shares in favor of any other person. D. This letter of offer can be sent by registered post, speed post, courier, or through electronic mode. E. If a shareholder does not respond to the rights issue within the period of the offer, the company can offer his shares to new investors. F. The company must raise minimum subscription, that is 90% of the issue. 3. State the provisions related to bonus shares. Answer. Bonus shares are the fully paid shares issued free of cost or as a gift to the existing equity shareholders by the company out of its accumulated or undistributed profits or reserves. Following provisions are to be fulfilled for issue of bonus shares. A. Bonus shares can be issued only out of free reserves or securities premium account or capital redemption reserve account. B. Company cannot issue bonus shares out of reserves created by revaluation of assets. C. Company cannot issue bonus shares instead of dividend. D. Once the announcement of bonus shares is made by the company, it cannot be revoked or withdrawn. E. Company can issue only fully paid bonus shares. F. Shareholders cannot renounce, that is, give away their bonus shares to another person. G. Minimum subscription criteria does not apply to bonus shares. 4. State the general principles or rules for allotment of shares. Answer. Allotment of shares means giving, or distributing shares, to share applicants, or to specific persons, with whom, company has entered into contracts. In addition to the statutory provisions, a company has to follow following general principles, or rules, for allotment of shares. 1. Proper authority. Allotment must be done by proper authority. This authority can be Board of Directors of the company, or the allotment committee, set up by the board for this purpose. 2. Allotment must be against application only. A company can allot shares only if it has received a written application for shares from the applicant. 3. Reasonable time. As per the Companies Act 2013, allotment has to be done within 60 days of receipt of application money. Company can start making allotment from the 5th day from the date of issue of prospectus. 4. Absolute and unconditional allotment. Prospectus and share application form contain the terms of allotment of shares. Shares should be allotted on the same terms. Company cannot add new conditions at the time of allotment. 5. Communication. The allotment must be duly communicated to the applicant by sending a letter of allotment or allotment advice. This letter gives details of shares allotted and allotment money due. 6. Allotment should not be in contravention, violation of any other law. Company has to ensure that the allotment of shares does not violate or contradict any other existing laws. For example, shares cannot be allotted to a minor. 5. State the contents of share certificate. Answer. A share certificate is a registered document issued by a company evidencing that the person named in the certificate is the owner of number of shares of company as specified in the certificate. The following are the contents of a share certificate. 1. Name of the company, CIN, registered office address. 2. Folio number. 3. Share certificate number. 4. Names of shareholder, shareholders. 5. Number and class of shares, that is whether preference or equity shares. 6. Distinctive number, numbers of the shares. 7. Nominal value and amount paid on each share. 8. Whether the face value is fully paid or partly paid. 9. Date of issue of share certificate. 10. Signature of 2 directors and 1 authorized signatory. 11. Common seal of the company. 6. What are the effects of forfeiture of shares? Answer. Forfeiture of shares means compulsory termination or cancellation of membership of a defaulting shareholder on account of non-payment of call on shares within a certain period. Shares can be forfeited only for non-payment of call. Shares cannot be forfeited for any other dues from the shareholders. Thus, only partly paid up shares can be forfeited. Following are the effects of forfeiture of shares. 1. Cessation of membership. The defaulting member ceases to be a member of the company and loses all membership rights as his name is removed from the register of members. 2. Liability of member. The defaulting member continues to be liable to pay the unpaid calls even after forfeiture of shares. However, his liability ceases when the company reissues the forfeited shares. 3. Liquidation of company. If the company goes into liquidation within 1 year of forfeiture of shares, the defaulting member is liable to pay the calls as a past member. 7. When can the board of directors refuse transfer of shares? Answer. Transfer of shares is a deliberate or voluntary act of transferring the property in shares by the member of a company in the name of some other person. Every member has a right to transfer his shares. He may transfer his shares for consideration or give away as gift. The member who transfers his shares is called transferor, and the person to whom the shares are to be transferred is called transferee. The member who is intending to transfer his shares has to fill up the instrument of transfer and submit the same, along with share certificate and required transfer fees, to the company. The board of directors of the company have the authority to refuse registration of transfer of shares in following conditions. 1. When the provisions given in the Articles of Association regarding transfer of shares are not fulfilled by the member. 2. When the instrument of transfer is not prepared as per the provisions of the Companies Act 2013. 3. When the instrument of transfer is not accompanied by the share certificate. 4. When the company has a lien on the shares to be transferred. 5. When transferee of partly paid shares is a minor. 6. When central government gives instructions to the company not to give effect to transfer of shares. 8. Explain employee stock option scheme. Answer. Under employee stock option scheme, that is ESOS, permanent employees, directors, or officers of the company, or its subsidiary company, or holding company, are given the right to purchase the equity shares of the company at a future date at a predetermined price. ESOS is an employee benefit plan which allows them to participate in the financial success and profitability of the company for which they are working through ownership of shares in the company. It is especially useful to those companies whose business performance depends upon the knowledge, skill, and experience of its employees. For example, software companies, media and advertising companies, etc. Provisions for issue of ESOS. Company has to comply with the following provisions related to ESOS. A. A company may offer the shares directly to the employees or through an employee welfare trust. B. Shares are to be offered at a price lesser than their market value. C. There should be a minimum vesting period of 1 year, during which the employee can use his option to apply for shares granted to him. D. Company will specify the lock-in period during which employee cannot sell his shares. E. Till the employees buy the shares issued to them, they do not enjoy any dividend or voting rights. F. For issuing ESOS, company has to get the approval of shareholders by passing a special resolution. G. The shares issued under ESOS to an employee shall not be transferable, pledged, hypothecated, or mortgaged. H. The company has to constitute a compensation committee for administration and superintendence of the ESOS as per the provisions of SEBI, Share-Based Employee Benefits, Regulations 2014. 9. What is calls on shares? Answer. Calls on shares can be defined as a demand made by the company on its shareholders to pay the whole or part of the unpaid balance on each share at any time during the lifetime of the company. Besides the application and allotment money, if a company demands the balance unpaid amount on shares, it is called calls on shares. Only board of directors of the company is authorized to make calls in the interest of the company. The amount of call should not exceed 25% of the nominal value of shares. The gap between two successive calls should not be less than 1 month. Company has to send call letters to the shareholders asking them to pay the call money. Company has to give minimum 14 days notice to pay the call money to the company's banker. If the shareholder fails to pay the call within the stipulated period, company can forfeit his shares. Articles of Association of Company contain rules and procedure to make calls. 10. What is transfer of shares? Answer. Transfer of shares is a deliberate or voluntary act of transferring the property in shares by the member of a company in the name of some other person. Every member has a right to transfer his shares. He may transfer his shares for consideration or give away as gift. The member who transfers his shares is called transferor, and the person to whom the shares are to be transferred is called transferee. Shares of a public limited company are freely transferable. However, there are certain limitations on transfer of shares of private limited company. A member can transfer all the shares held by him, known as total transfer, or part of the shares held by him, known as partial transfer. For transfer of shares, an instrument, called instrument of transfer, should be filled in by both the parties and signed by the transferor, transferee, and a witness. It has to be submitted to the company along with share certificate and required transfer fees. The application for the registration of transfer may be made either by the transferor or by the transferee. If the transfer of partly paid up shares is lodged by transferor, then the company must give notice to the transferee. Transfer of shares can take place after receiving no objection to the transfer from transferee. However, if the application for transfer of partly paid shares is made by the transferee, such a notice is not required to be given. A transfer of shares applied by the legal representative of a deceased member of a company is valid. Transfer is said to be completed only when transfer is registered in the register of members. Once the shares are transferred, the liability of the transferor ends. In case the shares are held in electronic form, transfer of shares is automatically done. Stamp duty is required to be paid in physical transfer, but in electronic mode of transfer, no stamp duty is payable.